Good morning, everybody. My name is Jason Hollon, and I'm here with my partner, Ann Tyler Morgan. And we want to start off by thanking you for being with us this morning to discuss what we believe to be a very important topic for all healthcare entities, and one that is constantly evolving and has had some significant developments over the last few weeks. I myself am for the most part, an employment law attorney and also focus on a lot of litigation. And Ann Tyler is one significant part of her practice is dealing with CMS and Medicare and Medicaid. So what we're going to talk about today kind of blends both of those topics and is something that all of you need to be aware of and know what is going to be required of your entities. Today, as part of our learning objectives, we are seeking to understand the requirements of CMS's final rule regarding mandatory COVID-19 vaccinations for healthcare entity staff. We're going to discuss what is going to be required by CMS to have an effective vaccination policy. And then we're going to talk about how to develop a plan to meet those requirements and what the deadlines are under CMS's interim rule. And so to start off, we'll kind of talk about here a little bit the background of the CMS vaccine mandate. This is something that's been covered in the news significantly, but just kind of a little quick rundown. I think we all remember that back at the end of August or early September, President Biden announced that his administration would be requiring vaccine mandates for primarily two categories of entities, and it would be going through two administrative agencies. The first one is CMS, which is the focus of our conversations today, but at the same time, OSHA was going to issue interim guidance that required vaccine mandates for employers with 100 or more employees. It took a little while for the administration to get out their interim rules, and on November 5th, both agencies, both CMS and OSHA, issued what's called interim rules that required these entities to have vaccine mandate policies. And with respect to CMS, the requirement is, as we're going to talk about extensively today, that for the most part, all staff of any healthcare entity that receives federal funding through Medicare or Medicaid, that their staff be fully vaccinated against COVID-19. Once these interim rules were put out, as expected, there were several lawsuits filed throughout the country, several in Kentucky. And as a result, the OSHA standard was stayed pending the Supreme Court's review of the matter. And then with respect to the CMS vaccine mandate, it was stayed in, I think it was 26 states before. So while the Supreme Court could review the issue. And in the middle of January or early January, the Supreme Court of the United States issued its decisions, I should say, and it found that the OSHA mandate was very likely unconstitutional and should be stayed pending any litigation, and ultimately OSHA has withdrawn that guidance. But with respect to the CMS guidance, the Supreme Court more or less okayed it to go forward. And so that's where we are today. Because of the Supreme Court's decision, the CMS interim rule requiring these vaccinations is going forward, and it has pretty quick deadlines that everyone needs to be aware of and come into compliance with. One note here on this slide, and this will be the last time we talk about the distinction between OSHA and CMS, is that the OSHA guidance allowed for a testing option that entities and employers could institute policies that their employees needed to be vaccinated or submit to weekly testing at their own expense and wearing masks. The CMS mandate does not provide for that option. And so with respect to the CMS requirement, for the most part, any staff at a facility, a healthcare facility that receives Medicare, Medicaid, is going to be required to be fully vaccinated against COVID-19, unless they qualify for what we'll discuss, a religious exemption, a medical accommodation under the Americans with Disabilities Act, or for some reason they have a medical contraindication that would suggest they should be delayed in getting the COVID vaccine. So that means that any staff of a healthcare entity, regardless of their patient contact, so we're talking about licensed practitioners, students, trainees, volunteers, they're included, and obviously anyone who provides care, treatment, or other services for patients under a contract or through any other arrangement, are going to be required to be vaccinated unless they meet one of these exemptions or accommodations. It does not apply to anyone who provides services exclusively outside your all's facilities, but for the most part, all staff are going to be covered. And so the timeline that we're looking at here, for the most part, because of the way that the case is played out, some states are on different timelines, but with respect to Kentucky, CMS has clarified that by the 14th of February of this year, obviously, the facilities, healthcare facilities must implement their vaccination policy, and all of the staff, unless they have a pending request for a religious exemption or medical accommodation, must have received at least one dose of a 2-dose COVID vaccination. If it's someone who's getting one of the 1-dose COVID-19 vaccines, then they have to have that done by February 14th. Also on this date, the entities must have gathered all of the records related to the vaccination status of their employees. And what you're looking for there is information about the type of vaccine that the employee had, the date of the administration, and the name of the healthcare facility that administered the vaccine. Those records should be kept confidential, just as you keep all other employee medical records. And all of that needs to be done obviously in a very short period of time here on February 14th. By March 15th, CMS is going to require that anyone who is doing the 2-dose vaccination have received all of those doses, which functionally means that by March 15th, 2022, everyone, all staff of a healthcare entity will be required to be fully vaccinated against COVID-19 unless they have been granted an exemption or an accommodation. While it's not in the slide here, one common question we get is touching on booster shots. CMS at this time recommends that policies, encourage folks to get boosters, but that's currently not part of the definition for fully vaccinated. So you're not going to be required to have received the booster, but it's encouraged to have that in your policies. And so, as I've been talking about, there are 3 ways in which employees or staff would not have to be fully vaccinated by the 15th. And the first one of those is a religious exemption under Title VII. And your policy should provide that exemption requests be submitted to HR to be documented and evaluated according to your policies that you should already have in place. These aren't new exemptions. They've been in existence under Title VII for a long time, and it's a similar analysis that you would make with respect to any religious exemption request that you might get. And the question here is, of course, whether or not the person has that they can't get a vaccination based upon a sincerely held religious belief. You can ask further questions of the employee or staff member, and look at, is it in reality a sincerely held belief? Important to note, the EEOC has said on multiple occasions that religion is defined very broadly, and it can mean a number of things outside even, than just traditional religions, but it does not extend to social, political, or, some kind of economic philosophy. It does have to be a religious belief. And then if in fact the employee does have a sincerely held religious belief, the analysis turns to whether or not that imposes an undue burden. And in the context of religious discrimination or religious exemptions, that is a minimal burden analysis on your all's operations. Similar to religious exemptions, another part of your policies needs to provide that individuals with medical issues be able to request accommodations under the Americans with Disabilities Act as to why they can't be vaccinated. This is, again, like the religious exemption. It's similar to any other reasonable accommodation analysis that you deal with all of your employees under the ADA. There are certain allergies that folks have that can require them to not be eligible for vaccines, or that they shouldn't get the vaccine. And to the extent someone is requesting such an accommodation, you can require them to provide documentation from a licensed practitioner, medical doctor, as to why that is and why that accommodation is needed. Another possible, the third and final way that an employee could not be vaccinated under one of these policies is that there's some sort of reason for there to be a temporary delay due to some sort of acute illness or treatment that they may have received because of a recent COVID-19 infection. As with all documentation of this nature, you need to make sure that your facility is documenting all of these issues and keeping it in a confidential file in the event that CMS comes in and wants to look at the records. And it's important that you have a timeline of where everybody is and why, if they're not vaccinated, why that is, and when the documents were received. With respect to all of those issues, whether it's a religious exemption, medical accommodation, or someone who is delaying their vaccination, CMS is going to require that the entity takes certain steps to implement procedures to reduce the transmission of COVID-19 as a result of unvaccinated employees, for whatever reason that they're unvaccinated. While CMS doesn't specifically say what accommodations would be appropriate or what measures would be appropriate, some suggestions have been obviously following any and all CDC recommendations on source control, requiring unvaccinated employees to wear N95 masks or higher in all areas, regardless of whether they're near patients or otherwise. And then also requiring employees to submit to weekly testing and submitting those test results to HR. Again, though, as with any accommodation request or exemption request of any nature, it's going to be on a case-by-case basis and looking at the actual needs of the facility and the reason for the exemption or the accommodation. And so I'm going to turn it over to Ann Tyler, who's going to talk about initially what are the consequences of non-compliance with CMS's requirements.
Perfect. Thank you, Jason. Well, this is the burning question because, of course, we've crafted policies for a number of our clients, and everybody wants to ask, if we don't do this, what happens? And for individual employees, we would say that the employees are obviously obligated, just as with any other policy that your facility implements, they are responsible for following it. The policies and procedures that we draft, for example, have a signature line where the employee attests having read and been given the opportunity to ask questions on the policy and procedure. And so by signing that, they are stating that they will follow it. If they don't follow it, then your facility may place the employee on unpaid leave until they comply, and you may follow up with disciplinary action up to and including termination. And of course, we would suggest that your policy includes some broad language like that so that it has some teeth to its enforcement power, that there may be disciplinary action up to and including termination. For facilities, there will be Health and Human Services Inspector General and other activity throughout the cabinet or throughout the department surveying facilities for compliance with this measure. And you can expect this to be fairly broad in nature. Of course, you're surveyed generally for compliance with HHS requirements, and this will be no exception. Those surveyors will assess your level of deficiency and then apply enforcement procedures accordingly. And that may include monetary penalties in the same course that your other disciplinary actions from HHS may take, and other disciplinary actions from the department. Of course, the biggest being pulling your funding, which nobody wants. So let's talk about what makes an effective and compliant policy, because part of the requirement, as Jason mentioned, under the CMS final rule, is that you actually, rather than simply ensuring that your employees are vaccinated by the deadline, you have to have a policy outlining exactly how they go about that, how you collect documentation from them, and so forth. So there should be a policy statement at the very beginning of the policy, briefly outlining the what and the why. This is a COVID-19 policy, and it's being implemented for the purpose of minimizing transmission of COVID-19 among employees and patients of the facility. And it should briefly lay out everything that's in the policy. So you'll want a couple of paragraphs essentially giving a thesis statement that employees pursuant to the CMS rule must be fully vaccinated against COVID by March 15th, unless they're found to be exempt pursuant to the terms of the policy. That if employees are hired after March 15th, they must be fully vaccinated by the time that they begin their employment, and that employees who fail to comply will face disciplinary measures up to and including termination, like we said. And then the policy should go into the actual procedure to be followed to ensure that employees are in compliance. And we're going to talk about how the policy will be enacted and what the employee should do to make sure that they're compliant. So first, you should tell them up front that there's no cost associated with receiving the vaccination, and that employees will be provided with PTO to receive the vaccination and recover from side effects. And generally, to receive the vaccination, that's 4 hours, and to recover from side effects, it's a day after that second dose. They should also be told how to submit to HR their record of vaccination. And that documentation, there are a number of documents that can perform the function of a vaccine card, but primarily here in the United States, that is a vaccination card showing the type, date, and who administered the vaccination by the specified deadlines, unless, of course, they submit an exemption request. The record should also, the policy should also state that records will be stored confidentially as protected health information. And as with all employee healthcare records, this should be kept separately from other records pertaining to the employee's performance. This is a medical record. The policy should also, as Jason briefly mentioned, provide some information on your facility's individual stance on the booster shot. Of course, the CDC currently recommends that employees If they're over 18 and they're past 6 months past their second dose of the vaccine, or if it's a 1-dose vaccine, 6 months past that dose, should receive an additional booster shot and submit proof of that to HR if your facility requires it. We're going to go again into the accommodation and exemption requests because this should be covered in your policy. Often this is treated as something like an addendum to the policy. This is a separate form that the employee can fill out if they choose, if they feel that those circumstances apply to them. And there should be a form for a religious accommodation request and for a medical accommodation or delay request. Those forms should specifically give space for the employee to state what the circumstances are of their request for accommodation or delay, and the process by which the facility will go about assessing those requests. If there's any particular timeline and that you anticipate reviewing those requests by, and laying out that you may be following up with them in asking additional questions. The accommodation process is usually fairly interactive. It's the employee coming to you with a request, you asking some questions. In the case that you work with us or another attorney, calling your attorney and getting a sense of what steps to take going forward, unless it's a very, very clear-cut exemption request. And this may take a couple of times back and forth with the employee to determine what is the best course of action. So again, those will be additional forms to your policy for a religious exemption request and for a medical exemption request. As Jason touched on, the factors for reviewing a religious exemption request are somewhat different than for a medical exemption request for a couple of reasons. One, the standard by which the employer is able to review their own burden in accepting the exemption or the accommodation is lower with a religious exemption request under EEOC requirements than that for a medical exemption. So keep that in mind. For a religious exemption, you do have to have only a de minimis burden, but you should still be reviewing whether there is a way to make that person's accommodation work if it's based on a sincerely held religious belief. And the medical exemption request form will generally also have a page for the person's healthcare provider to complete for you and stating from a clinical point of view why the person is ineligible to receive the COVID vaccine for medical reasons or requires a delay based on a recent COVID infection or some sort of secondary infection that would affect their ability to take the vaccine healthfully. For unvaccinated individuals, you have to describe in the policy what will happen to them, what the accommodation will be for them in the event that they do receive an accommodation. So generally, you can provide a broad statement saying that they may be required to mask, to socially distance, and to take other precautions, such as that weekly testing. And again, we'll draw the distinction here that under the CMS requirements, there's no ability to weekly test in exchange for receiving the vaccine if you can indeed take the vaccine. But if you do receive a medical accommodation, an exemption to your requirement to take the vaccine, then you may be expected as an accommodation to test weekly. So I do want to draw that distinction. It's not one or the other. It's simply an option for an accommodation if that applies. There are consequences potentially under state law for those individuals who are not exempt or have delayed vaccination, such as any state of emergency orders that go into effect that cause any lockdowns or any quarantine measures. So that can be mentioned briefly in your policy as well. There is a statement in the policy that is generally included that you may be familiar with other healthcare records that are maintained for your employees, particularly the Genus Statement. The Genetic Information Non-Discrimination Act prohibits you from requesting or requiring their genetic information. So the policy should actually say, do not include genetic information in your exemption requests or accommodation requests or any documentation about your vaccine. That vaccine documentation should be limited primarily to your vaccine card or other documentation that's available under the policy. It should also say that the vaccine is not a substitute for other measures that the facility may require. You still may be expected, of course, to follow other recommendations from time to time to curb transmission, including masking, including social distancing, depending on current states of emergency and current CDC guidelines. So this is part of a broader effort to curb COVID-19 transmissions. And in terms of enacting and distributing the facility's policy, you want to make sure, of course, that everyone receives it and that it is sent straight from HR or from the facility's leadership or an executive. You want to make sure that the policy is taken seriously, that everyone knows that it will be implemented, and that they are truly subject to disciplinary action if they don't follow that policy. And you'll want to establish a plan to confidentially store that vaccine information and to take it in an organized manner and to follow up on those compliance deadlines. After that first February 14th deadline for the first dose, you'll want some sort of mechanism in place to automatically follow up with employees for their second dose to make sure that everyone is vaccinated or exempt by March 15th. So the takeaways are, of course, pursuant to these rules and the fact that these court cases took a little while and new deadlines have been implemented in light of that litigation and the original rules, you'll need to act quickly. You'll need to review your requirements to make sure they're workable for your facility and that they're communicated efficiently and effectively to your staff. And we always say contact your attorney, but it's very true in these situations. You'll want to make sure your policy is compliant because there's a very good chance that surveyors will review it for you when the time comes for them to check on your facility. And particularly in the case of exemption and accommodation requests, the easiest thing to do when these situations get tricky is to pick up the phone and have a bit of a brainstorming conversation with your attorney about whether, for example, a religious belief is sincerely held based on all the evidence to you about, whether that employee has taken actions to the contrary of the beliefs that they're stating and so forth. We deal with these frequently. We can usually have a conversation fairly quickly with clients about exactly what to do in that circumstance or what the EEOC guidelines would suggest you do based on the circumstances you're facing. So always feel free to pick up the phone and let us know when you are reviewing one of those requests. So we're happy to answer any questions for you. Jason and I have been on the legal front lines of this crisis. We know you all have been on the true front lines of it. We've been dealing with the ever-changing regulations pursuant to COVID-19 and on the state and federal level since this began. I don't think we could have ever predicted how many twists and turns the law would take on this subject, but we're always here to answer your questions and always here to help you navigate what has been truly a difficult time, not just from a clinical perspective, but from a legal perspective for all of your facilities. We want to enable you to do your day jobs and truly treat patients. So please call us if you need us. We're happy to talk to you anytime. It looks like we've got some questions. An employee had an allergic reaction in their clinic where they were treated over 15 years ago has closed. They have not received any vaccinations, I'm assuming, since this reaction. So I'm going to take a shot at this and then Jason may weigh in. Typically with a medical exemption request, you're going to need a statement, particularly from that person's healthcare provider saying why they would have an allergic reaction to this vaccine. So just a general stance that I don't receive vaccines because of an old allergic reaction may not be sufficient. And certainly as an employer, you're entitled to request an opinion from their healthcare provider that they may receive or they may have an allergic reaction to the vaccine. Jason, do you have anything to add?
No, well, a little bit, I guess. That's right. With respect to the CMS's interim rules and regulations, your employee's going to have to submit some kind of medical documentation from a licensed practitioner that they need that. In the case that they've had some kind of allergic reaction, they should be able to get that documentation by going to their current medical provider and explaining the situation. And so, yeah, you would need to have that documented and to establish that that's an accommodation that would be appropriate. And then if that accommodation is appropriate, then you would need to take those measures we talked about to curb the transmission of COVID-19 in the workplace. With respect, I see there's another question that says the 100 employees statement on the regulations. Is there a different regulatory burden for employers with less than 100 employees? And I'll let Ann Tyler jump in if she has different information, but it's my understanding and is that this is likely coming from the OSHA regulation, that the CMS's regulation does not have a minimum employee number. The 100 employees is an import from that other regulation that was issued by OSHA that's now been withdrawn and as a result of the Supreme Court's decision. So these regulations from CMS that we've been talking about today are going to be applicable to everyone regardless of their number of employees.
That's right. I see a question. Will your slides be available for printing? I'm going to look at our marketing director.
Hi, I'm Brian Powers. I'm the marketing director. I'm happily not on camera, but do want to let everybody know that we are going to send the slides and a copy of this video out to all registrants. Please feel free to send that on to whomever might find the information useful. And you should see that with us from us within a day or two.
Perfect, thank you. See, we do have teleworkers that are not vaccinated due to medical exemptions. Do they need to be tested weekly, which is our policy for other non-vaccinated staff? For folks who are never in contact with patients, that you can test them weekly. If they are never coming into the facility, I do believe that there is an exception for that under the rule. And Jason, if you have any other information.
Yeah, I mean, my thought on that would be that one, if they're not coming into the facility, like Ann Tyler was saying, then they're not going to be required to get the vaccine anyways under CMS's regulations. But to the extent that you have them on telework, because that would just be a form of an accommodation under the policy. And so while we listed out, and I listed some of those possible accommodations, which include testing and the N95 masks, that is a case-by-case basis. And so if you're looking at, is it reasonable, and that's the standard, is it reasonable what you're doing to curb COVID-19 transmission? I would think that if someone never comes into the office, that they don't have to be tested.
Right. And I would say, because it is a form of accommodation, and just generally, you will want to thoroughly document why they're teleworking, why they're able to telework, and the fact that they are not coming into the clinic. I'll follow up on that point briefly and say that we have had questions in the past with facilities who had employees teleworking who occasionally needed to come in and gather patient documentation or something else for the performance of their duties by telework. And I would say that provisions need to be made that that person would come in after hours when no one else is in the building, in the facility, so that they are truly not facing any other employees or any patients, because that's the only way that the not testing and not vaccinating piece of telework works, is that they don't gather or commingle with their coworkers in a way that might expose their coworkers. So you'll want to thoroughly document the policy for that and place it in their file, just as you would the vaccine documentation, so that if there's ever a question, it can be very easily answered. I don't see any other questions, but you all have our, oh, I see one just pop up. Good timing. Did the 15 states that sued recently have any effect on the implementation of the vaccine mandate? Is there a stay? I'll let Jason answer this, but as he said, no, there is not currently. These rules are currently in effect for Kentucky. They had an effect in terms of they did change the timelines, but everything we've said today in terms of the timelines and the requirements are currently in force, and we don't anticipate that there will be a change now.
Yeah, I would agree with that. That the Supreme Court has dealt with those stays, and the CMS rule is going into effect, and with respect in Kentucky, it's going into effect and starting on February 14th.
All right. Well, feel free to reach out to us. We're happy to talk to you anytime, and we hope that you all have a great week.
Thank you.